All right, welcome everybody to our SoloSuit webinar. We're going to be talking about how to resolve a debt lawsuit. It's 5 o'clock. I'm going to go ahead and get started. Thanks for coming. Thanks for joining. I'm just going to go through some of the basics on how to use our website, how all of our products work together, and what the best strategy is for winning your debt collection lawsuit. I'm just going to get into that, and then once I've gone over the basics, I'm going to be taking questions from everybody. Feel free to just put a question down into the chat, and then we'll do our best to answer that. And I want to start off also by saying that I'm not an attorney. I'm not a licensed attorney. This isn't legal advice. It doesn't replace the advice of an attorney either. All right, so SoloSuit. With SoloSuit, our customers enjoy about a 70% win rate. Without SoloSuit, people rarely win their debt collection lawsuits. More than 90% of the time, they actually lose their lawsuit. But with SoloSuit, about 70% of the time, our customers win. And how we define win is they either get the case dismissed, meaning just like an outright victory in court, or they settle the case, which oftentimes is actually the best resolution. Or third, they manage to delay defeat. So they keep the case going so they can file for bankruptcy or they can do something else like that. As you might be learning right now, debt sharks or debt collectors exploit people in the system, right? So this scenario might sound familiar to you. Let's take the real life example of Raquel here in the bottom left corner. She gets sued for a $1,000 debt, and she wants to respond to the lawsuit. So the first thing that she does is she tries to talk to an attorney, but she finds out an attorney costs like $3,000 just to respond to the lawsuit. She doesn't have money for that. So then she tries to DIY her solution. She tries to respond on her own, but then she finds out that making the answer document's really hard, and she needs the mailing address for the court, which she doesn't have. And then she finds out there's a filing fee with the court, and she doesn't know how much it is or how to calculate the filing fee. And then she realizes she needs to print her documents, but she doesn't have a printer. And then she finds out she has to do snail mail. She has to mail that document into the court, which can be quite difficult. Figuring out how to use USPS. And then by the time she figures all that out, her 21-day deadline has passed, and she automatically loses her lawsuit. Now she's on the hook for a $3,600 debt because it's practically ballooned overnight from $1,000 into this $3,600 debt. And then her wages are getting garnished at 25% out of every paycheck. So that's a bad situation for Raquel. Thankfully, SoloSuit changes all of that, and we can help you resolve your debt lawsuit. So, first step is to answer the lawsuit. So you can use our service to file an answer to the lawsuit. You can also use us if you're in a credit card lawsuit. You can use us to file a motion to compel arbitration. And then ultimately you get the nice resolution, which is settling the debt. So first, let's take a look at the answer to the lawsuit. So one of the main reasons why a lot of people come to SoloSuit is they want to respond to the debt collection lawsuit. You do that by filing what's called a capital A answer document. Okay, so step one, you start making the answer document. You respond to each claim in the complaint and summons. And then step two, you assert your affirmative defenses. And step three, you file your answer document before the deadline. So you can do all of this with SoloSuit. You just go to solosuit.com. You click on the reply to a lawsuit button. And then you click the get started button. And then we'll just walk you through it. You make an account. It's free to make an account. You just need your email address. You just punch it in there. And then we'll walk you through this process. We'll get the basic information for the case. Then we'll help you respond to each paragraph in the complaint. Then we'll also even help you assert your affirmative defenses. You'll find that a lot of free forms online, even the forms provided by the court, they oftentimes don't deal with affirmative defenses, and that is a big problem. Affirmative defenses are very important, and you can only bring them up once, which is in the answer. So you got to bring them up in the answer. And then probably the hardest part about this whole process is actually filing the answer document in court. So you can pay SoloSuit to file the document for you in court. You can also pay us, we'll even have an attorney review the document for you. Filing an answer is important because it helps you get closer to settling. It gets you more leverage to settle. Second thing, you can use our motion to compel arbitration. You just click one of the arbitration buttons on our website, and then you can go through the process to generate a motion to compel arbitration. Kind of goes through the same process. We just get some basic information about your case. The main criteria here is like what state you're in, and then we'll make sure that the proper state statute is cited in the document. With our motion to compel arbitration, it gets a little bit tricky to file in court, so right now you just have to file it on your own. And there's a lot of things that can happen after you file a motion to compel arbitration. The judge might reject the motion, in which case the case will just proceed normally. You might actually get into arbitration, like it's approved, and then you have to get into arbitration. Usually your contract with a credit card agreement is framed up in such a way that makes the creditor pay for arbitration, which is nice because that could cost them like a few $1,000s if they actually want to proceed with arbitration. And then third, your case could just get dismissed. The creditor or the collector could just say, hey, I don't want to go through all this stuff, we're just going to dismiss the case. If it's not dismissed after filing a motion to compel arbitration, again, this is helping you get more leverage to settle. And that's where our other tool comes in. You can settle the debt. So debts settle for only 45% on average. That's huge savings, right? So if you're being sued for like $10,000, oftentimes debts like that would settle for only $4,500, meaning you'd save $5,500, which is great. We have a new tool called SoloSettle. You can find that on our website as well. People love it. Here's a review from one of our first customers, Dan. He said, I hope I never get sued again, but if I do, I would use SoloSettle again in a heartbeat. So you can just make an offer for free using SoloSettle. You just do that from our website, answer a few questions, takes about 5 minutes, and then we relay that offer to the collector and help you get the debt settled. So, in summary, SoloSuit makes winning easy. We take this same example of Raquel. Say she's sued for a $1,000 debt. This time she finds SoloSuit. This time she gets the debt lawsuit settled, and she gets on her way. She saves thousands of dollars. People are talking about SoloSuit. I've been featured in quite a bit of press, including National Public Radio, NPR, and Fast Company. Talk about how great our tool is and how much it helps people. Most importantly to me, our customers love us. We have a 4.8 star rating on Google. Lots of people leave us just 5-star reviews because they're pretty happy when their debt gets dismissed and they end up saving thousands of dollars. All right, that's the basics. You can resolve your debt lawsuit with SoloSuit. Looks like we got quite a few people watching, which is great. Glad you're here with us. If you have any questions about your particular situation, go ahead and write questions into the chat. And we'll do our best to answer them. Since we can't give legal advice, we can't apply the law to your specific facts. However, we'll do what we can here. Okay, looks like some questions are coming in. That's great. Give me just 1 second. Alrighty, we got one question here from Michael. How do I settle my debt amount in full after being served? I've heard that settlement agreements are inadmissible in court. Okay, so first question, how do I settle my debt amount in full after being served. So the way to settle the debt, so it sounds like you just want to settle the debt. Basically, the easiest way to do that is to use SoloSettle. I can kind of walk you through that process. So I'll show you just briefly how to do it using SoloSettle, and then I can also show you how to do it on your own if you would like as well. Give me just 1 second to pull that up. All right, so here's SoloSettle. You just go here, it's on the main page for the website, so if you're on SoloSuit.com, feel free to follow along with me if you'd like. Just go here, you click Settle a Debt Lawsuit, then you click the Get Started button. Alrighty, and then you just choose your state that you're in. Let's say I'm in Florida. And you go through, you type in your name as it is on the complaint. So you want to have the complaint with you next to you. If you don't, it's no big deal. You can really just type in your name as it is. That'll be fine. Just type in the name of the lawyer suing you. Type in the law firm. And then we match your law firm with our database to make sure that it's like going to the right place. You gotta have an email address for the lawyer. Just type in support@solosuit.com. If you don't have an email address, you can use this blog post, handy blog post we have here. We have a directory for all the attorneys across the US and every state. A lot of these directories list the email addresses of the attorneys, so you can click on one of these and type in the name of the attorney and try to find the email address for them there. Once you have that, you type it in, and then you come in here, you type in the name of the plaintiff. That's like the person that's actually suing you rather than the law firm that works for them. Again, we match that. Type in the civil number. This is equal to the case number. Type in the amount that you are being sued for. So let's say you're being sued for $10,000. Just type that in. And here's the the main part. Type in the amount that you'd like to offer as a settlement. So there's no exact science here on like how much you should settle for, how much they're going to settle for, etc. Really, you just kind of base it on two factors. One, how much do they want to? How much do you think the collector is going to accept for settlement? And then two, how much do you have to pay for settlement? Right. So if you're being sued for $10,000 debt, you have $10,000. You don't want to settle for $10,000 because that can you'd be paying the full amount. But let's say you could easily pay $7,000 on the debt. Then you make an offer for $7,000. That's 70% of the debt. Collector's pretty likely to accept that. We've found that collectors are usually quite ready to settle for something around 80%. But definitely you can get them down lower to 30, 40%. So in this example, let's say we make an offer of $7,000, and then we click continue, and this shows how everything would break down. Total savings in this scenario would be $1,100, which is a big win. And then when you're ready to do it, you just click submit, and then we'll make sure that offer gets over to the collector for you. And yep, and you'll be using our software to settle your own debt. Just as a note, SoloSuit is not a debt settlement firm. You're just using our software to settle your own debt. All right, so that's one idea. If you don't want to use SoloSettle, you can settle the debt on your own. Some ways to do that: you can send a letter to the collector, you can make a phone call to them. Basically, you just want to come up with an offer that you can afford within 30 to 90 days, and you make that offer. Don't expect them to accept the first offer that you make. You're probably going to have to make 1 or 2 offers before it gets resolved. And then just kind of wrapping up the question here, you want to make sure you get the settlement agreement, you get it signed, and then you do want to file that in court. In most cases, you are going to file the settlement agreement in court. All right, moving on to some other questions here. From 29, I use SoloSuit to respond already. I have a debt suit on a secured loan. They never picked up the car they had the title for and still have the title. Does this help me to resolve or win my case? It sounds like you're asking if responding to the lawsuit does help you resolve or win your case. Yes, it does. Yes. In pretty much every situation, filing an answer is the best option for the person being sued for debt because it asserts your rights. Even if you do owe the debt, you should still file an answer because it asserts your rights, and coming to a settlement is much better than having a default judgment against you. In regards to a car, usually, if it's a secured credit, usually the collector is going to repossess the car. Okay. From my man Marvin, why all of a sudden debt collectors are suing people? Well, Marvin, interesting question there. Debt collectors have been suing people for quite a while, for about 20 plus years now, I believe. Buying debt from creditors has been a legal practice, and collectors usually buy the debt and then they sue people for it. That said, it has the number of lawsuits has at least doubled in the last decade or so, and usually there are more lawsuits coming every year, especially now that household debt across the U.S. is higher than it has ever been before in history. A lot of debt is coming due. All right, going rapid fire here. DNA Realty, can I use this in Canada? You can certainly try it out. Feel free to go through our free answer. See if it generates an answer that's valid in Canada. SoloSettle, settling a lawsuit. You can also try making an offer in Canada and see where it gets you. Let's see. All right, Mike. Moving on to Mike. Does SoloSuit work before you get sued? Seems like it is formatted for after a lawsuit is filed. Good question, Mike. Good question. We're primarily set up for lawsuits. Primarily set up to help people after they get sued. However, we do have some products to help people before they get sued. Mainly, if you're on SoloSuit.com, you want to go here to reply to a collection letter. A collection letter is the term we use to refer to just a letter or a phone call from a collector that is not a lawsuit. And you can do this and get started. What this will do is it'll generate debt validation letter for you. You just answer a few basic questions. It takes maybe 10 minutes to fill it out. And then you'll mail this letter to the collector. You can also copy it and email it to them. And it will require that they validate the debt, that they provide proof of the debt under the FDCPA. In regards to SoloSettle, particularly Mike, again, SoloSettle is designed right now primarily for people in lawsuits. However, if you wanted to, there isn't much stopping you from just trying to enter in the information relevant to something before a lawsuit, and seeing if the tool will work for you. Instead of entering a case number, for example, you could try entering a file number for the collection matter, and that correspondence will get sent to the collector all the same. All right. Someone asked if you can use this tool in California. Yes, you can, 100%. California is one of our most popular states. It works really well in California. You can use our answer service, any of our documents in SoloSettle in California. Bud asked, what if you don't have the money to pay? If you don't have the money to pay, then, even still, it's better to file an answer. And some reasons are, if you file an answer, you're blocking yourself from default judgment. You're making it less likely that you're going to get a judgment. You have a pretty good chance of just getting the case dismissed just by filing an answer. If you don't file an answer, you get the judgment against you. And judgments last basically forever, right? So the statute of limitations, like when a debt expires, that's maybe usually like 5 to 8 years, depending on the state. A judgment usually is 10 to 20 years, so usually they last for 10 to 20 years, and most of the time they're infinitely renewable. You just file documents, renew them. So if you ever make money again in your life, or if you ever have property again in your life, then the collector will be able to come after you for that once they get a judgment against you. All right, we got Nelly. And also I see that Hannah is also, she works at SoloSuit. She's also responding to some of these questions, which is great. I'm just going to be giving a little bit more of a verbal response here as well. Let's see. My summons was served to, Nelly asked, my summons was served to my father and not myself. Is this a misservice? Depends on a few factors. I can't give legal advice on your particular case, but generally speaking, improper service occurs if they don't follow the rules of service that are laid out in the rules of civil procedure for your state. Oftentimes, the state will allow a adult member of your household to receive the documents for you. So if like someone's father lives in their house and the defendant isn't home and the server gives the documents to the father, it's probably going to be valid. If the father doesn't live in the person's house, then no, that would probably not be valid. And SoloSuit makes it easy to bring up the affirmative defense of improper service. All right, P. After we have used SoloSuit to respond to the summons, should we wait a few days to hear if the debt collector responds to the answer before contacting them to settle? Great question, one that people ask frequently. The key here is to file an answer and to offer to settle. Doesn't matter very much what order you do it in, but the key is to do both of them together. So you can come to our site, you can go to SoloSettle and then make an offer, and then in that same day, you can fill out the documentation for the answer document and send that in. And the SoloSettle offer will get to the collector first, and then maybe a few days later the answer document will get to them, and that's fine. That's totally fine. The main thing is you want to make sure an answer is filed, and you also usually will want to try to settle. Filing an answer makes you have more leverage to settle. If it were me, I'd probably go to the website. I'd fill out and file an answer document, and then immediately after that, once I paid to send off the answer document, I'd then send a offer to settle. Rosemary asked, I was sued by Midland Funding. Sorry to hear it. We help people with Midland Funding all the time. They're probably one of our top debt collectors that we deal with. A-Ray asked, if you already made payments on a debt before finding SoloSuit and respond to a lawsuit asking them for proof of the original agreement, does it still help my case? Let me just make sure I understand that here real quick. If you already made payments on a debt before finding SoloSuit and respond to a lawsuit asking them for proof of the original agreement, does it still help my case? Yeah, sure. I'd say so. I'm not sure I exactly understand the question, but yeah, if you have somebody who's trying to collect a debt from you and it's pre-lawsuit, just send them our debt validation letter. If it is in a lawsuit, then you can send them our answer document. And both of those request proof of the debt. Both of those documents request proof. Trela, does SoloSuit offer assistance with filing a motion? Do we do any motions? Yeah, we do a motion to compel arbitration, which utilizes the arbitration clause in a credit card agreement. You can generate that document on our site. You have to file it on your own. Motions get a little bit tricky to file, so we don't have a service around filing those yet at this time. You can read our blog, though. Our blog has a lot of helpful resources on how to file motions. If it does go to court, this is from P6, if it does go to court, I'm in Kentucky. Because it involves money, can I request a jury to hear the case? Usually in these civil lawsuits, yeah, you can request a jury trial. You'll usually have to pay money. Maybe it's around like $100 to request a jury trial. I wasn't served anything, this is from DNA, I wasn't served anything previous to an email I just received. Okay, yep, well, you can send them a debt validation letter. You know, if you receive a collection attempt, you can send them a debt validation letter, or you can send them an offer to settle if you're familiar with the debt. All right, let's see. Rosemary, I was sued back in 2021 by Midland Funding. I just found out. However, this account was opened back in 2011. I never knew about the account. How do I settle this, especially if it's back in 2011? I guess the age that the account was opened, generally speaking, doesn't really matter that much. Usually what matters is like the last time that somebody made a payment. And from the last time that somebody made a payment, the statute of limitations starts ticking from that time. Let's see some of the questions here. We got Simon. He helped me last week to send the answer for the court. What do I have to do next? Great question, Simon. Generally speaking, what a lot of people do and they have success with this is they file an answer with us and then they go to SoloSettle and they make an offer to settle the lawsuit. So that's SoloSuit.com/SoloSettle, or you can just click the Settle a Debt Lawsuit button on our main site, and then you can make an offer for free to the collector. R asked, can creditors go after your Social Security? Great question, R. I'm not particularly sure about that. And if you'll send them, I believe we have an article about that one. I believe it varies from state to state. Generally speaking, I believe there are restrictions around what they can collect in Social Security. But I believe in some cases they can collect it a little bit less directly. But, you know, this kind of depends on like specific facts of your situation. Crystal, I didn't respond to the summons in time as it went to an address I no longer am at. Now the default against me has already been filed. What do I do? And can SoloSuit help with that? I'm in California. Sorry to hear it, Crystal. Unfortunately, that's a situation we come across a lot, way more than we'd like to. It's called sewer service. It's called sewer service because basically the collector sticks the documents in the sewer instead of giving them to you. In this case, you know, it sounds like maybe it went to your old address. Ultimately, good judges and good courts don't want people to lose on technicalities. So they should allow you an opportunity to answer. What people oftentimes do in this situation is they will file a motion to set aside judgment, also known as a motion to vacate judgment. And with that motion, they'll file an answer document. You can do that on our site. You just create an answer document on our site, email us at support@solosuit.com, and ask us to send you a motion to set aside judgment template, and then you can fill that out. Janelle asked, can we use this in Kansas? Yes, you can. Can use it in Kansas. We're operating in Kansas. R asked, can creditors... Oh, lost that question here. Can creditors go after annuities that have been annuitized and you're collecting payments monthly? Interesting question. An annuity is a contract between you and an insurance company that requires the insurer to make payments to you either immediately or in the future. Good question. I don't know the answer to that one off the top of my head. Perhaps Hannah can provide some additional resources there. And I'll look into that one for you. Mike, if we compel arbitration and the lawsuit is dismissed, can we have it removed from the credit files? So I guess you're saying, if you get a case dismissed, does that mean that the debt should be removed from your credit report? Generally speaking, I don't believe that is the case. I'm not certain on that one. A lawsuit dismissal isn't the same as like a clear victory of the lawsuit. If the lawsuit is dismissed, generally speaking, that just means that the lawsuit was like withdrawn. It's different than going through with a jury trial or going through with a hearing and actually having the judge or the jury give a judgment or a verdict of some sort. So I'm not sure, but I wouldn't think that generally speaking, a lawsuit being dismissed means that the debt will be removed from the credit report. All right, and it's now 5:32. I appreciate all you guys' questions. This is our first webinar, actually. We are scheduled to end at 5:30, so we're already a few minutes over. Looks like Hannah has responded to people's comments for the most part. I'm going to skip to the most recent ones just to make sure that we are catching people here. I also just want to say, thank you for attending. Very glad that we could help you out. If we haven't gotten to your question, we're going to try to finish up on responding to these comments, and then also feel free to email us at support@solosuit.com, and we'd love to get you taken care of. I definitely want each one of you that's here in attendance, I want you to win your lawsuit and get the justice that you deserve. So this last question I'm going to answer here from Aaron. Cavalry Portfolio Services is filing on me. I have used SoloSuit Premium. They never even contacted me about the filing. Can they do that? Yeah, that's kind of getting back at the sewer service situation there, Aaron. It's kind of this weird situation where the judge is not the referee in court. So the plaintiff can serve someone by sewer service, meaning they never actually served the defendant. And then the court won't really verify that the person was served. And the only way that the court will find out that you weren't served properly is if you tell the court you weren't served properly. Pretty crazy enigma, right? Because you can't tell them you weren't served properly if you were never served. Thankfully, it sounds like you found out that you were served, and you should certainly bring up, you can in this kind of situation, people can certainly bring up an improper service defense, and our answer document makes that pretty easy to do. You just say you're improperly served, and there you go. Then you file the answer and get that done. All right. It's been great chatting with all of you. Have a good night. Again, feel free to follow up with us. Thanks a lot. Just one last thing before we go, actually, just getting to Kevin's question. He said, I don't have a complaint. I have a certificate of service of plaintiff, first set of discovery. What's the difference? Discovery is like the second stage of a lawsuit. On the first stage, you have the pleadings, which include the complaint, summons, and answer document. After that, you move into discovery. And there you go, that's the difference. The answer is to the complaint and summons. To respond to discovery, usually you'll need like a response to interrogatories or something like that. All right, take care.